When you let the people come in by the thousands and thousands and thousands, they made a terrible mistake.
Inside America's immigration courts, something unusual has been unfolding, not at the southern border and not during late-night raids, but in quiet hallways where legal cases are supposed to end, not begin. Investigations reported by Associated Press and Reuters confirmed that more than 2,000 migrants were taken into custody by ICE immediately after court hearings over just a few months, turning routine legal proceedings into flashpoints of enforcement. These arrests were not random. Federal prosecutors and government attorneys coordinated motions to dismiss cases on the spot, a move that stripped migrants of temporary legal protection and allowed ICE officers to act within minutes, often just steps outside the courtroom. American media described this as one of the most significant shifts in ICE tactics in years, pushing enforcement into spaces long viewed as legally neutral. Federal officials argue the strategy prevents risky individuals from slipping back into communities, while judges and immigration lawyers warn that due process is being compressed at alarming speed. The real issue runs deeper than arrest numbers. It forces a hard look at how far enforcement can go before it begins to reshape the foundations of American justice itself.
At 9:17 a.m., the hallway outside an immigration courtroom was packed, the air thick with nervous relief. Families waited on hard benches, lawyers checked their notes, and migrants stepped out of courtrooms believing their cases were finally over. Then everything snapped. From both sides of the corridor, plainclothes officers closed in, hands locking onto their arms before anyone could react. The sound of handcuffs echoed off the walls as security guards froze the crowd in place. This was not a mistake. It was the moment the trap was sprung. This scene did not happen once. It happened thousands of times in court buildings across the United States. The shock was not only the scale, but the target. Many of those detained had no criminal convictions at all. Their cases had simply been dismissed minutes earlier by a judge. The twist that unsettled the country was not the handcuffs, but the timing and location. Justice did not end at the courtroom door. It began there. When a courtroom turns from a place of resolution into the starting point of an arrest, who is really in control of justice in America? If you want to understand how this operation was planned and what it means for the future of U.S. enforcement, subscribe to Military Power, because what comes next may change how you see America's courts forever. As the second Trump administration moved deeper into office, immigration enforcement entered a noticeably sharper phase, one defined less by border chases and more by precision inside the system itself. According to reporting by Reuters and Associated Press, ICE quietly shifted resources toward people already inside the legal process, turning court schedules and case outcomes into enforcement triggers rather than endpoints. This was not a return to old methods. It was a recalibration. The data revealed how dramatic that shift was. Within just a few months, the number of ICE detainees without criminal convictions surged by more than 2,000%, a spike that stood out even by historical standards. Reporters confirmed that many of those taken into custody had no prior criminal record at all. Their presence in court was tied solely to immigration status, not violence or serious crime. Yet the system now treated timing as everything. The central character in this story was not a single agency or official, but a tightly synchronized federal machine. ICE officers did not act alone. They worked alongside the Department of Homeland Security, government prosecutors, and immigration courts, each playing a specific role. Prosecutors identified cases likely to be dismissed. Judges ruled on those motions. ICE teams positioned themselves just beyond courtroom doors, already briefed and waiting. The process unfolded quietly, efficiently, and with little room for hesitation. Crucially, the goal was never mass roundups. Instead, the focus narrowed to a precise moment. When a judge dismissed a case, even for procedural reasons, the migrant lost temporary legal protection almost instantly. That dismissal created a narrow window, sometimes only minutes long, in which ICE could lawfully step in. What looked like a routine legal decision suddenly became the switch that activated detention. For federal officials, the logic was straightforward. They argued that acting at this moment prevented people from disappearing into the interior of the country, closing gaps that had existed for years. However, immigration attorneys interviewed by major outlets warned that this compressed timeline left little opportunity to respond or seek relief, transforming a courthouse visit into a sudden point of no return. That tension defines the heart of this operation. When the law creates a gap that lasts only minutes, who controls what happens inside it? And how much power should exist in that brief space between freedom and detention? What made this operation so effective was not force, but timing. Inside immigration courts, ICE was no longer reacting. It was waiting. According to investigations published by Reuters and Associated Press, officers arrived each morning with pre-prepared lists, names tied to cases expected to be dismissed that same day. These lists were not guesses. They were built from court calendars, prosecutor filings, and internal coordination that mapped out who would lose legal protection within hours. The officers did not sit inside courtrooms or stand beside judges. Instead, they positioned themselves in hallways, near elevators, and by glass exits where people naturally drift after hearings. To anyone watching, they looked like regular staff or visitors. There were no uniforms, no raised voices, no visible show of authority. That silence was intentional. The goal was control without chaos. When a judge dismissed a case, the switch flipped. The migrant stepped outside, believing the hardest part was over. In many instances, lawyers were still gathering papers, families were reaching for phones, and relief was just beginning to sink in. That was the moment ICE moved. Officers closed in calmly, identifying themselves only when hands were already on arms. Detentions took seconds, not minutes. There were no chases, no arguments, and rarely any resistance. Reporters noted that this lack of resistance was not accidental. Most of those detained believed they were legally safe. Their cases had ended. They assumed the courthouse was neutral ground. By the time confusion set in, it was already too late. Security guards sealed off hallways, elevators were held. The building continued operating as if nothing had happened. This method reduced confrontation and public disruption, a detail ICE officials later pointed to as proof of professionalism. Yet critics interviewed by major outlets warned that this quiet efficiency masked something deeper. The courthouse, long seen as a place where legal disputes conclude, had been transformed into a trigger point for enforcement. The twist that unsettled observers was not the arrests themselves. It was the realization that the hearing was never the finish line. It was the activation signal. A legal proceeding meant to resolve uncertainty had instead become the final step in a carefully staged trap, one that closed the moment relief appeared. If ICE could move with such perfect timing in courthouse hallways, what legal switch was being flipped inside the courtroom to make those arrests possible within minutes? What truly accelerated this operation was a quiet procedural shift that most people inside the courtroom barely noticed. Instead of filing written motions that could take days or weeks to process, government prosecutors began asking judges to dismiss cases verbally right there in the hearing room. This method, known inside the system as oral dismissal, changed everything. According to reporting by Reuters, between May and July 2025 alone, prosecutors submitted more than 6,600 oral motions to dismiss immigration cases nationwide, a volume that far exceeded normal practice and immediately caught the attention of legal observers. Under standard procedure, written dismissals create a buffer. Migrants and their lawyers usually have time to respond, file appeals, or seek alternative relief before enforcement actions begin. Oral dismissals erased that buffer entirely. Once the judge agreed, the case ended in seconds. There was no waiting period, no paperwork delay, and no warning beyond a few spoken words from the bench. For the migrant sitting in the courtroom, it sounded like closure. In reality, it was exposure. Investigations by Associated Press explain why this mattered so much. The moment a case was dismissed, even for technical or administrative reasons, the individual lost temporary legal protection. That change in status allowed ICE to immediately place the person into expedited removal, a fast-track process designed to move cases out of the system as quickly as possible. Officers waiting outside did not need additional authorization. The legal switch had already been flipped. From an enforcement perspective, the appeal was obvious. Oral dismissals cut through layers of bureaucracy that had slowed removals for years. There were no documents to file, no deadlines to monitor, and no opportunity for cases to linger. Everything moved at courtroom speed, measured in minutes rather than months. Officials later argued this efficiency closed long-standing gaps that allowed people to remain in the country despite removal orders. However, immigration attorneys interviewed by major outlets warned that speed came at a cost. With no response window, migrants often did not understand what had happened until ICE officers approached them outside. By then, the process was irreversible. What felt like a routine hearing had quietly turned into a one-way door. That is the core tension of this tactic. When speed becomes the system's main advantage, control shifts to whoever decides when the trigger is pulled. If efficiency is the weapon, the question becomes unavoidable. Who controls the trigger and who bears the consequences when it is fired? As the operation expanded, a new and unsettling pattern began to emerge, one that had nothing to do with individual cases and everything to do with geography. Across the United States, the same federal immigration law was being applied in sharply different ways, depending on which city a migrant happened to stand in. Reporting by Reuters revealed that immigration courts in cities such as Los Angeles and Atlanta approved nearly all oral motions to dismiss brought by government prosecutors during this period. In those courtrooms, the process moved fast and predictably. Cases were dismissed in seconds, and ICE arrests followed almost immediately outside the door. In contrast, New York told a very different story. According to investigations published by Associated Press, immigration judges in New York approved far fewer oral dismissals, often pushing back against the practice or requiring additional steps. As a result, many migrants who would have been detained instantly in other cities walked out of New York court buildings without incident. The difference was not behavior, criminal history, or risk level. It was simply location. This divide exposed a deeper tension inside the system. Federal immigration law is supposed to operate uniformly across the country, yet the outcome of a case increasingly depended on local court culture and judicial discretion. In Los Angeles and Atlanta, cooperation between prosecutors and courts created a smooth enforcement pipeline. In New York, skepticism toward oral dismissals slowed that pipeline, sometimes stopping it altogether. For migrants and their families, this inconsistency felt arbitrary and deeply confusing. Journalists noted how quickly word spread within immigrant communities. Courthouses in some cities became places of fear, while others were still seen as relatively safe. Lawyers began advising clients differently depending on the city, not the law itself. The same hearing that triggered detention in Georgia might lead to freedom in Manhattan. This uneven reality challenged the idea that justice is blind to geography. Federal officials defended the variation by pointing to judicial independence, arguing that judges are free to rule as they see fit. Critics countered that such wide disparities undermine confidence in the system. When outcomes shift based on zip code, trust erodes. The twist was hard to ignore. The law had not changed. The rules on paper were identical from coast to coast. Yet for thousands of migrants, justice felt radically different depending on where they stood. In this operation, America revealed itself as uneven terrain, where the courtroom door could mean detention in one city and release in another, all under the same flag and the same law. When the same law produces completely different outcomes depending on the city, what happens when the federal government decides to override that imbalance with a named high-intensity operation? As the courthouse-based strategy gained momentum, the Department of Homeland Security pushed the effort into a more aggressive and clearly defined phase, one marked by a name that conveyed urgency, scale, and intent. In Chicago, DHS unveiled Operation Midway Blitz, a concentrated enforcement surge that went beyond routine court arrests and explicitly tied immigration enforcement to public safety priorities. Reporting by Reuters explained that the operation focused on migrants whose cases had been dismissed or stalled, particularly those who appeared in broader law enforcement databases, even when they had no criminal convictions. The message was subtle but firm. Immigration enforcement was no longer operating in isolation. It was being framed as part of a wider security response. Chicago quickly became a proving ground. ICE teams coordinated closely with federal offices in the region, synchronizing arrests with court calendars, release schedules, and known appearance dates. Timing was everything. Officers were positioned to act the moment legal protection ended, often within minutes of a hearing's conclusion. The impact was immediate and impossible to ignore. Data cited by the Associated Press showed that daily ICE detentions in the Chicago area surged by more than 1,400% during the peak of the operation. What had previously been a slow, steady flow of arrests suddenly turned into a wave, stretching detention facilities and drawing intense national attention. Federal officials defended the surge as both deliberate and necessary. DHS framed Operation Midway Blitz as a direct response to public safety concerns, arguing that early intervention reduced the likelihood of repeat offenses and prevented individuals from slipping back into communities once their cases ended. In briefings covered by major news outlets, officials emphasized that the operation was targeted rather than indiscriminate. From their perspective, acting quickly at the precise moment legal protection expired was not about punishment, but prevention. Speed, they argued, closed gaps that had existed for years. On the ground, however, the effects were felt far beyond official talking points. Immigration courts across Chicago took on a heavier, more tense atmosphere. Lawyers reported clients missing routine check-ins and scheduled appointments because they had been detained without warning after hearings. Families described sudden disappearances that began with what they believed would be a routine court date. A morning trip to the courthouse increasingly carried the weight of uncertainty. Although the operation operated within existing enforcement authority, its intensity set it apart from previous efforts and reshaped daily expectations inside and outside court buildings. Journalists following the story noted that even the branding mattered. Giving the enforcement surge a formal name signaled a campaign mindset, one that resembled large-scale law enforcement or even military-style operations rather than ordinary civil procedures. That framing reinforced the idea that immigration control had entered an emergency posture, at least in selected cities. The name itself suggested urgency and action, preparing the public for a different pace and a different level of enforcement. Supporters of Operation Midway Blitz pointed to clear results. Arrest numbers rose sharply, and DHS cited the surge as proof that coordinated federal action could close long-standing enforcement gaps. From this view, Chicago demonstrated what was possible when agencies moved in unison. Critics, however, raised a different concern. They questioned whether tying immigration enforcement so tightly to public safety blurred important lines and reduced oversight. When arrests accelerate at this speed, they argued, errors become harder to detect and harder to correct. Operation Midway Blitz ultimately exposed the central dilemma behind the entire strategy. If rapid action truly prevents harm, then speed becomes a virtue. Yet when speed dominates every decision, safeguards begin to shrink. The question that lingered over Chicago did not stay there for long. It echoed nationwide. Does public safety justify every method used to achieve it? Or does the cost in fairness and trust eventually outweigh the gains? Just as the enforcement surge appeared unstoppable, the system pushed back. The turning point came not at the border or in the streets, but inside federal courtrooms far removed from immigration hearings. According to reporting by Reuters, several federal judges issued rulings that sharply limited ICE's ability to carry out warrantless arrests tied to courthouse operations. These decisions did not question immigration law itself. Instead, they focused on how enforcement was being executed and whether constitutional safeguards were being bypassed in the process. The impact was immediate. Courts ordered the release of hundreds of detainees who had been arrested under the new tactics, particularly in cases where judges found that arrests occurred without proper warrants or clear notice. As documented by Associated Press, some rulings temporarily blocked ICE from making arrests in or around certain courthouses, forcing officers to stand down in places where they had operated freely just days earlier. For families waiting outside detention centers, the shift felt sudden and dramatic. People who had vanished after hearings began reappearing. sometimes with little explanation beyond a court order. The Department of Homeland Security responded forcefully. Officials argued that the rulings undermined public safety by slowing the removal of individuals they described as high risk or repeat offenders. In statements covered by major outlets, DHS warned that restricting enforcement tools could allow people to evade authorities and disappear into the interior, recreating the very gaps the new strategy was designed to close. From their perspective, the courts were interfering with lawful executive authority during a critical enforcement phase. What followed was a visible clash between branches of government. Immigration enforcement, once framed as an administrative process, became a constitutional battleground. Lawyers debated due process. Judges scrutinized arrest procedures. ICE adjusted tactics, sometimes pulling back, sometimes testing new boundaries. The quiet efficiency of hallway arrests gave way to legal uncertainty and nationwide scrutiny. Observers noted the irony. A federal government that had coordinated across agencies with military-like precision now found itself slowed by its own judicial system. The same courts that enabled dismissals and enforcement windows were now erecting barriers around them. The machinery of the state had collided with the brakes built into it by design. This was the twist few anticipated. The most significant resistance to the operation did not come from protests or politics, but from within the federal system itself. When judges stepped in, they reminded the country that power in the United States is not meant to move in one direction only. The struggle that followed was not just about immigration, it was about limits. When enforcement accelerates, who decides when it has gone too far, and what happens when the system answers back? By the time the courtroom doors began closing again, one fact was impossible to ignore. ICE had shown that it could move fast, quietly, and with a level of coordination that resembled a precision operation rather than routine civil enforcement. Investigations by Reuters and Associated Press documented how thousands of arrests were carried out in a matter of months, often within minutes of legal protection disappearing. From a tactical standpoint, the message was clear. The federal government still has the ability to act decisively when it chooses to do so. Yet the same reporting also revealed the cracks beneath that speed. Legal challenges, uneven court decisions, and judicial pushback exposed how fragile the balance can be when enforcement accelerates faster than the system designed to oversee it. In one city, a courthouse became a trigger point for detention. In another, judges slowed the process and blocked it entirely. The law did not change, but the experience of justice did. That is why this story matters far beyond immigration policy. It forces the country to confront a difficult trade-off. How much speed is acceptable before procedure is hollowed out? How much authority should be concentrated in a narrow window measured in minutes? Federal officials argue that rapid action protects communities and prevents people from slipping through the cracks. Critics counter that once safeguards shrink, rebuilding trust becomes far harder. And this story is not. Court rulings continue to shift. Policies are adjusted, challenged, and rewritten. What happens next will shape how power is exercised in moments of legal transition, not just in immigration courts, but across the system. So now the question turns to you. Do you see this as a necessary step to protect America, or a dangerous precedent that pushes enforcement too far? Share your thoughts in the comments and subscribe to Military Power for deeper analysis of the quiet operations that are reshaping the world in ways most people never see.